Welcome back to Brick by Brick. I'm Roxann Klepper. So today, it's sort of a sensitive topic for lots of people. And it's something that I'm sure lots of people have gone through. My husband and I are going through it right now. And so we're just going to talk about kind of what it takes to navigate that whole process, because it can be like navigating a hurricane on a dinghy. So welcome back to Trista Carey. Thanks so much for being with us again. So Trista, I'm all about the real life stories. So tell us kind of a scary story about things you've experienced where someone has maybe not had a will and kind of the consequences of not doing these things.
Absolutely. So we see that all the time, far too frequently. Just to provide some context and background, when someone dies without having a valid will, it's called an intestacy. And in that situation, the legislation dictates who will administer the estate and where it will go. Contrary to popular belief, the government doesn't get it all, but they do control where it goes. And so it's really important that we understand that in order to understand how these unfortunate situations can occur. So the first story I'm going to share with you occurred when I was early in this area of practice for me. A young lady contacted me. Her dad had recently passed away. He didn't have a will. And she was very close with her dad, as was her teenage son. And so her dad had made statements to lots of family and friends about how he wanted everything to go to his daughter, along with some classic cars he and his grandson had worked on that he wanted to go to his grandson, who was a minor. The problem was that he also had a son he was estranged from and had been estranged for probably in excess of 20 years. Because he never wrote down what his wishes were into a document that could be considered a valid will, it was an intestacy. And under the legislation, the son and daughter shared his estate equally. And the daughter was very devastated by this, and her son did not end up with the cars that her father had wanted him to receive. Unfortunately, our legislation is mandatory. And so when you don't have a will, you leave yourself open to those situations.
So when someone comes in to see you about a will, obviously the will is one form, but what's the process to actually create the will? You know, obviously there's a lot to it, and there must be more than just the will document when they're coming in to see you about it. So what is the process and what else is involved?
Sure. So when clients come to see me, there's actually a pre-planning part to it. So I send clients out a planning guide that they fill out and return to me in advance of our first meeting. And in doing that, they provide me with a whole lot of information about themselves, their family, and what they have. That allows me to do a little bit of pre-planning as well to identify where we might need to talk about certain things. We might need to plan for certain things, including tax implications to assets. So it's really important when you are planning for this that you spend some time in advance of that first meeting thinking about who do you have and what do you have, right? Identifying not just the assets and the liabilities, but also how are they owned? Are they owned jointly? Are they owned jointly with a spouse or with someone else, like a child or a sibling? Or are they in your own sole name? Sometimes with proper planning, we can identify where there might be problems, whether those are tax or administration problems, and correct that so that the estate is as streamlined, efficient, and tax effective as possible.
Okay, that makes sense. And so are there other documents besides just the will when someone comes in to see you? Are there other things you encourage people to have done at the same time as a will?
Absolutely.
Okay.
So there are 3 estate planning documents that I always encourage clients to have. Obviously a will, which everyone is familiar with, which is that roadmap for your estate plan. But in addition to that, every adult over the age of majority who has capacity should have a personal directive and an enduring power of attorney. A personal directive is a document that appoints someone to make personal decisions for you, such as healthcare or accommodations, if you lose capacity for any period of time during your lifetime. And an enduring power of attorney is a document that allows someone to make financial decisions for you, usually again in the context of a lack of capacity. And that just ensures there's a continuity of decision making during your lifetime. And those documents no longer have any effect upon death, and the will speaks from death onward. So they are three separate, distinct documents that all serve a purpose and all work together.
Okay, so just to clarify for our audience, in case someone doesn't know that, can you tell us what capacity means in relation to making decisions for yourself?
So it will depend on the context, but generally mental capacity means having the reasonable ability to make decisions relating to your person or to your finances, including understanding the consequences of any decisions you make.
Okay, so you got your will, which is your roadmap, your personal directive, which is like another roadmap for your health decisions and things like that. And then you have your, what was the last one?
Power of attorney.
Power of attorney. Power of attorney. Enduring power of attorney for someone who can say if you need to sell a house, if you have to take money out of a bank account, close bank accounts, things like that.
File taxes, make investment decisions. Yeah. And so the critical piece to understand is that it doesn't matter whether you're married or single. Every adult needs a power of attorney, because although you might have joint bank accounts with your spouse, you might even be jointly on title. If you have to deal with that real estate and one of the parties has lost capacity, you have to have a power of attorney, or you have to have a trusteeship order in order for your spouse to sign on your behalf. Same thing with filing your taxes and making investment decisions for solely owned investments like RRSPs or RIFs or TFSAs, which can only be owned in one person's sole name and not held jointly.
Okay. Ooh, complicated, which is why no one should have a will kit.
Exactly.
Right? Okay. And so from a tax perspective, once someone has a will that has to come into place, what are the benefits then to that person's family of having this will?
So when we are dealing with planning on a pre-mortem or before death basis, we can ensure that assets are held in such a way that we can minimize the tax implications. There are tax deferred rollovers that we may be able to take advantage of under the Income Tax Act. We can also look at ensuring that beneficiary designations are used effectively. And in some cases, we might need to utilize a trust, either for minor beneficiaries or for a spouse if we're looking at a blended family or second marriage type arrangement. So there's all sorts of different tax implications and tax planning that we can do if we know in advance.
Okay, that's good information. So Trista, what are the top reasons why you would encourage people to have a will in the first place?
So there's several. One, when you go to a lawyer, you're getting legal advice and their expertise in terms of understanding the application of the legislation and the court rules as they govern the drafting and interpretation of wills, as well as the administration of an estate. Most importantly, you maintain control over what happens to all of those assets you've worked so hard to accumulate during your lifetime, and ensuring that you've got the right people in place to both administer the estate and to receive those assets. As we've mentioned, there can be some really critical tax planning depending on the types of assets that people own. And I would say any person who has minor children or potentially grandchildren that they want to provide for need to ensure they have a will. I can't imagine anything worse as a parent than leaving it up to the courts or family members to fight over who wants my children or who doesn't want my children. Especially when we all have very clear ideas about how we want to raise our children and who would be most consistent with that. So guardianship is a huge piece of wills for anyone that has minor children involved in their situation. We also have the ability, when we're talking about minors, or individuals who have any sort of cognitive disabilities, to ensure that we're putting funds into trusts so that those can be managed for their maintenance and benefit during their lifetime. It may be that we're trying to ensure that we don't interfere with government funding, or we just want to ensure that the money is available for these minors and that it's controlled by someone we trust up until the point where we think those children are old enough and responsible enough to make those good decisions for themselves. If we don't have that in place, then often the public trustee ends up being the person or the entity controlling those funds for the minors, and they will receive those funds at the age of 18 18, whether or not they're responsible enough to manage those funds. That includes ineffective planning for designated assets, such as your registered investments, your life insurance, your pension, and other assets like that. So it's really critical.
Yeah. Wow.
And then ultimately, I think once you have those documents in place, you simply have that peace of mind knowing that you have a plan. So unfortunately, all of us will die sooner or later. It's just a question of whether we die with a plan or without a plan.
And having that weight of the world off your shoulders has to be a huge relief to people once they have it all documented and in place.
It is. And it's something that clients tell me consistently after we leave, after the signing is complete, they will tell me they just feel so much better knowing that they have something in place. Should the worst and the unforeseen happen to them, they know that their loved ones are taken care of.
I think that's something else that we didn't touch on is it's so great to, like you said, to plan and have it all in place. But how often does something very unfortunate happen, like cancer or a car accident, happen before you've got to the planning part of it? And then, now you're SOL.
Yeah, and that's the unfortunate part. So as much as it's easy to procrastinate on this because we all think we're 10 feet tall and bulletproof, it's really critical to plan when you're not in a crisis.
Yes, very much so. Okay, I feel like we just touched just the tip of the iceberg there, but Trista has so much knowledge and all of this stuff, as you can tell, just a wealth of wisdom there. So for those of you who maybe have a will kit or don't have a will at all or are thinking of redoing it, I'm going to really encourage you to reach out and do that. And Trista is fabulous at this. So Trista is with Schnell Hardy Jones. I am going to link all of her contact info into this podcast so you can reach out and use her knowledge and wisdom to your benefit. Thanks so much for being here, Trista. That was awesome.
Thanks, Rox.